All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Welcome. This is Arizona Court of Appeals, cause number CA-CV130169. I'll note that we have some guests in the audience today from the externs from the Supreme Court, Arizona Supreme Court. Is that correct? Or
The Arizona Department of Administration.
Arizona Department of Administration. So welcome, and hope you enjoy these proceedings. For the appellants and the appellees, for the parties, for your information, this proceeding is being recorded. If you wait a couple of weeks, hopefully, if all the equipment works correctly, you'll be able to see yourselves on YouTube. Yay! Your 15 minutes of fame. As you approach the podium, please identify yourself and your client before you commence your argument. Each side will have 20 minutes to present their argument, and the podium will indicate how much time you have left. Appellant, you may reserve a portion of your time for rebuttal, and if you would like to reserve 5 or 10 minutes, if you'll tell us how much, we'll try not to horn in on your time. We have read the briefs and discussed the case in conference this morning, reviewed relevant portions of the record, and so with that in mind, you may begin.
Good morning. I'm Richard Hunley. I represent the appellant, Louis Caruso, and I would like to reserve 5 minutes of time.
Okay, thank you.
Excuse the voice. I'm fighting a little bit of a cold, but I'm not the only one. The appeal that we have brought is from a January 7th, 2013 judgment, which was issued in the Family Law Trial Court. The appeal is primarily directed to the judgment's denial of Mr. Caruso's motion for new trial. That motion for new trial raised 2 grounds. The first was the effect of the 1-year statute of limitations on the contempt finding and the purge payments that were established. The second issue was the request for the new trial due to the ineffective assistance of counsel at the trial. The court's ruling was issued November 13th, 2012. It found Mr. Caruso owed $194,000 or thereabouts in accrued spousal support. It was a finding based upon his ex-wife's contempt petition. The amount was later adjusted to $188,000. The ruling also found Mr. Caruso in contempt as to the entire amount and set quarterly purge payments, requiring him to pay the total purge amount, the total amount owed, or face incarceration. Now, Mr. Caruso acknowledges he owes this money. That was never at issue in the underlying case. He agreed to a non-modifiable support provision in his consent decree. It turned out not to be a wise decision because he subsequently lost his business during the economic downturn, but he realizes he owes the money. The issue, though, is whether and to what extent the contempt remedy can be opposed against him. The amount of the judgment, $188,000, runs from January 2010 until the time of trial in November 2012. The petition for contempt itself was filed in February 2012. In the motion for new trial, we first argued that under ARS Section 12865, there's a 1-year statute of limitations applicable to contempt proceedings. The motion for new trial argued that the contempt finding and the purge amounts went beyond that 1-year period. It should have been limited to amounts that came due from February 2011 and after. Instead, it went back to January 2010, and it's a difference of about $82,000.
And so what's Mother's remedy for the other arrearages under your theory?
She has a judgment that is still enforceable in every other way, just not by contempt. The contempt remedy is the 1-year statute of limitations. So in effect, she'll still have a judgment. She has a judgment which is good forever as long as she renews it. But only the amounts that come due within 1 year of the filing can get you thrown in jail if you don't make the payment.
So the statute of limitations argument is an affirmative defense to the contempt proceedings?
Not necessarily. And this is what gave rise to the appeal. When we brought the motion for new trial, the judge rejected that. He said under Sparks versus Republic, you have to bring the statute of statute of limitations defense prior to the date judgment is issued. But judgment had not yet been issued. The judge's ruling, he titled it judgment, but in its body he said this is not the final judgment, this is not appealable, this is just a minute entry. So then we cited other case law to show him, well, first of all, we showed that he had not issued a judgment yet. But the judge then came back and said, well, I'm still going to deny it. You have to raise a statute of limitations defense prior to the time of trial. And that's just not true. We've cited 4 different cases, the Sparks case, Romo, Harris Trust, Transamerica. Each of them are unanimous that the statute of limitations is waived if you don't raise it prior to judgment.
But those cases all talk about either where there has been a trial and then the defendant raises it, so it's post-verdict, so to speak, or there hasn't been a trial, and because there hasn't been a trial, there's still an opportunity to amend the pleadings. In this case, you raise it for the very first time in a motion for new motion for new trial, which is it's kind of somewhere in between. And but in the cases where there has been a trial, the evidence has been taken, a verdict has been entered. Why should we extend the extend that defense to that period of time between the close of evidence and the final judgment?
Well, I think for 3 reasons. The first is the case law is unanimous that you have to raise it before the judgment is issued. The second is, remember, this is a family law case. Family law rules of procedure are slightly different than the civil rules, and we have Rule 34B, amendments to conform to the evidence. You can raise these issues even after judgment according to that rule. But the third reason is no new evidence is required. The elements of the statute of limitation defense is fleshed out during the trial. I mean, unlike a lot of other defenses, it's pretty straightforward. When did the cause of action accrue? Here, when did the support obligation accrue? And was it paid? So that evidence was already in the trial. And under Rule 34B in this family law proceeding, we could have even brought this motion after the judgment was issued to say that, look, under the record, yes, he owes the money. Here's when it accrued, but you can only go so far back to hit him with the contempt penalty.
But if in fact it is a defense under the Arizona Rules of Family Law Procedure, how do you get around 32F?
32F is the one that says you have to...
I'll read it to you. A party waives all defenses and objections not presented either by motion or in that party's answer or response, except, and then it leads to a group of exceptions.
Okay. No response is required under Rule 92 to a contempt proceeding. That's how you get around that. This is one of the special procedures in family law because of its quasi-criminal nature, where you don't necessarily have to file a response.
Your motion was brought under 83A1.
Right, a motion for new trial. I toyed with whether to do a motion to conform with the evidence or a motion for new trial. I thought since the ruling had already been issued, it made more sense to do a motion for new trial.
What was the irregularity in the proceedings that occurred? Not the irregularity in the pleading. And the motion hadn't been arrived at that point. The motion hadn't been filed at that point. What was the irregularity in the proceedings that led to what you believe to be the court's abuse of discretion?
That's the second ground. That's on the inefficient assistance of counsel.
Only?
Only. It was 83A6 that the statute of limitations issue was brought, 83A1 that the ineffective assistance of counsel was brought. In the ineffective assistance of counsel, again, that was not even considered by the trial court. It was rejected out of hand without getting to the merits with the finding that that argument doesn't work in a civil case. And that's flat out wrong. We've cited the cases. There's a Nordenson case, which is a family law case, which did say this ground does exist in family law cases. If it's not just basic attorney negligence, it has to go beyond that. It's a tough standard. I think the phrase that they used in that one was flagrant misconduct.
Doesn't a lot of the case law address the fact that it needs to rise almost to the level of abandonment of the client?
Well, there's flagrant misconduct in one case. There's positive misconduct in the Phoenix Pezzino case. Yes, it has to come close to abandonment, and that's what our motion for new trial argued. I mean, it might be we're not going to win on that ground because it's such a high standard, but the trial court at least has to consider the ground. They just took it, Judge Gerlach just took it, said this ground doesn't exist, denied. He didn't exercise his discretion in even considering the argument.
Okay, so your objection is not that it applies, but that he didn't even consider it in the course of his.
That's right. As to that ground, our objection is, our request is that it be remanded so a trial court will consider the motion under those grounds. Under the statute of limitations, our request is that it be remanded and the judgment corrected so that the contempt penalty falls in line with the 1-year statute of limitations.
Thank you.
Okay. And Judge Gerlach did something in dealing with the statute of limitations issue which still bothers me very much. In his first ruling, as I mentioned, he says that I'm rejecting this because you have to raise it before the judgment is issued. Here's the case on it, Sparks versus Republic. So I brought a motion for reconsideration and said, Judge, you're right, but you haven't issued a judgment yet. Then the judge said, and I did that by way of a motion for reconsideration. The judge then denied the motion for reconsideration, said, yes, the court, I am wrong, no judgment has been issued yet, but I don't see any authority for the proposition that a statute of limitations is not waived if not raised at trial. But the judge had it in his prior ruling, the Sparks case, it was there. And then the judge went on to cite 5 cases, none of which had anything to do with the statute of limitations defense. There were basically objections that need to be made at trial as to witnesses or as to evidence and things like that. So it came across that the judge has decided who was going to win, and now he was going to try to tailor the law to meet his how he thinks the results should be, and that was just not fair on this. The statute of limitations is timely raised in this case under either the case law, which says it has to be done before judgment is issued, or under the family law rule 8034B, which allows things to be raised even after judgment is issued. I think it needs to go back to the trial court for consideration, first of all, of what effect this 1-year statute of limitations has on the contempt. I mean, it's still going to be, Mr. Caruso is still going to owe the same amount. He's still going to have purge payments. But if I'm correct, the purge payments, the amount that can be subject to the purge payments is just not as heavy as Judge Gerlach has made it. And I think it also needs to go back to the trial court to at least consider the motion for new trial on the inefficient assistance of counsel argument. And I can go into how bad the counsel was, but that's really not a decision for you. Your decision is just whether that's a ground that the court should consider. There was a third and relatively minor issue that we appealed. That was the attorney fee award. It's a $14,900 amount. Judge Gerlach, in his ruling in November 2012, said, I'm going to award attorney's fees in an amount to be decided to the ex-wife because Mr. Caruso raised ridiculous or took unmeritorious positions at a settlement conference, which increased the cost of this litigation. The mother then submitted a fee application for 100% of her fees incurred. We submitted a response and said, well, wait a minute. The Judge Gerlach's ruling is just looking at the additional cost raised by the position taken at the settlement conference. We itemized what those would be, and we said if you take the settlement conference to trial, those fees are X, I think about $7,000. That's what the award should be. Judge Gerlach, though, then without comment gave the ex-wife all her attorney's fees. Under Rule 25324A, specific findings are supposed to be made on fee awards when they're based on the reasonableness of positions taken. That was not done here. That's another reason it needs to go back to the trial court to back up its finding of attorney's fees. If the attorney's fees are just to be limited to how the cost increased because of positions taken at the settlement conference, it needs to be explained how mother then got 100% of her attorney's fees going back to day 1 of the case. Unless there are any other questions, I will.
Okay.
Thank you very much.
You. Yes.
Good morning, Your Honors. Carrie Wilcox for the respondent, Kimberly Caruso, appellee. Mr. Hunley and I saw each other 2 weeks ago. We both now have colds, so I'm not sure if we shook hands and traded something. But with respect to the statute of limitations, Mr. Hunley is correct that that defense is not required to be asserted in a pleading if the pleading that there doesn't require a response. However, I can direct the court to Index Item 40, which is a minute entry from Judge Gerlach. This was with respect to a resolution management conference that we had prior to the contempt hearing. This was in May 2012. And at that time, Judge Gerlach ordered my client and I to amend our petition for contempt because it did not comply with Rule 91 of the Arizona Rules of Family Law Procedure. Opposing counsel referenced Rule 92, which addresses civil contempt, but Rule 91 addresses petitions to enforce payment of spousal support. Rule 91 says that the respondent is required to file a response to that petition. And then if we get back to Rule 32 tells us that if a response is required to be filed, then that defense must be raised in the response. So pursuant to the judge's order in May 2012, we filed an amended petition. That amended petition is Index Item number 35. Husband, appellant, filed a response to that amended petition, Index Item number 39. The defense was not raised in that response. I believe that's decisive of the issue on their own argument. The reply brief clearly states that if it has to be asserted in the response, if the rule requires it, the rule clearly requires under Rule 91 that a response be filed. With respect to the ineffective assistance of counsel, I think the court did address substantively those issues. I think that appellant's argument opens the door for trial after trial. I can conceive of a situation in which Mr. Caruso may go hire another attorney, be unhappy with the outcome of that trial, and where does it stop? And certainly, this is not a criminal matter. He had a choice about who he wanted to hire. He had a choice about evidence to be presented. And more importantly, I don't think that the conduct of his former attorney rises at all to the standard that's described in Nordenson.
Did you try this case?
I did try this case.
Did the conduct of counsel, to your observation, rise to the level of something that was near abandonment of the client's interest?
Absolutely not.
How long was the trial?
The trial was a half day.
How many exhibits were entered or utilized?
I believe that prior to trial, they had approximately 10 to 12 exhibits marked. He may have had 4 or 5 admitted.
How many witnesses were called?
He called his client and his client's new wife, Ms. Caruso.
Did he list anyone else that he wasn't able to get in because of time constraints?
I don't recall, Your Honor. There was no one else present. In other words, he may have identified additional witnesses but did not bring them to trial.
Thank you.
I would agree that Mr. Anderson's performance was not fabulous, but he did show up. He participated in the pretrial process. He participated in the ADR process. He had exhibits marked. He examined witnesses. He cross-examined my client. He had exhibits admitted. You know, I don't know that being a bad attorney is the same as not showing up.
Was there any indication from the trial court that it was frustrated with counsel's participation?
You mean it prior to or during the?
During the trial?
No. The only frustration that Judge Gerlach exhibited was the attempt to introduce exhibits that they had not previously disclosed. In other words, this case had been going on since January 2012. This trial was in November. There was ample time to disclose any documents that they would have wanted to produce. And I particularly recall one document that was dated several years prior to the proceedings. Clearly, appellant and his counsel would have known about this document, so an attempt to pull it out of a file and produce it at the time of trial was offensive to Judge Gerlach.
Thank you.
With respect to the issue of attorney's fees, counsel argues that the trial court did not adequately identify the reason for awarding fees. However, the rule requires that appellant ask the court to make those specific findings prior to the findings being made. And appellant concedes that he did not make those requests in his objection to the application for attorney's fees. But even if he could argue that he somehow did, I believe that the rulings the trial court entered meet those requirements under 25-324. Anything
else? Okay.
Thank you.
Thank you very much.
Now, I told our audience that the courts like to give the attorneys a hard time, so feel free to...
Well, we're giving you a hard time, isn't that good?
Oh, that's true, that's fine. Let me comment, let me speak to a couple points counsel raised. Rule 91 is for petitions for enforcement. Rule 92 is petitions for contempt. There was contempt here, which is why you have that special rule that you don't have to file a response. You don't have to raise everything in your response if you do file a response. But Judge Jones asked whether the judge showed any frustrations with anything about the presentation. I just want to read you part of his ruling. This is the ruling that was filed November 13th, the ruling he called a judgment, which was not actually a judgment. On page 2 in spousal maintenance, he starts out with this. What stands out more than anything is the evidence presented by way of Exhibits 40, 41, and 42, showing substantial amounts of money deposited into bank accounts that, at least at times relevant here, Mr. Caruso controlled, and Mr. Caruso's complete failure to explain that evidence, i.e., Mr. Caruso offered no testimony to rebut what, according to Ms. Caruso, those exhibits revealed about Mr. Caruso's financial wherewithal. Those exhibits alone make Mr. Caruso's assertions about limited financial resources unavailing. So that is the judge's frustration, because what he was presented with, Ms. Wilcox's client presented bank account statements from Mr. Caruso's company before it closed and he went bankrupt, and the new business that he was working for that his new wife started. He got these bank statements that said, oh, you're putting in $50,000, $60,000 a month. It was left without rebut as to that it wasn't Mr. Caruso's money and that this was gross income. Obviously, a business's gross income doesn't mean it has net income. This was an HVAC company, so while it might be putting $60,000 of cash in a bank account each month, it's spending about $55,000 a month on its salary and to buy HVAC equipment for its clients. For whatever reason, the attorney did not address these issues. At some point during the hearing, the transcript reads as if he just kind of stopped the fight. It got so bad that Mr. Caruso left the table by his counsel and went and sat in the audience. Mr. Caruso was mortified that things had not been disclosed that he had given him months before and was not being put into evidence. But again, we're not asking you to decide the ineffective assistance of counsel issue. We're just asking you to confirm that it exists in Arizona. It's a high standard, the flagrant misconduct, positive misconduct, close to abandonment of the client, and then send it back to the trial court to consider the motion with that directive.
You say that the conduct of counsel, and I don't remember your words exactly, basically conceded the issue or conceded the point, something along that line, on the issue of whether this was gross income or net income and whether or not it was something that she had versus he had.
Not conceded, just didn't direct it. Just did not question his client or the other witness on it.
Is there any reason to believe that this was discussed with him at any point and that wasn't a tactical decision on his part?
It was not a tactical decision. I believe the declarations we submitted with the motion for new trial at the trial court level talked about how they were ready to testify these things, and the attorney just stopped his presentation. If it was tactical, I don't know what the tactic would be. It clearly was not a tactic that was either discussed with the clients or successful, even according to Judge Gerlach's own words.
How many trials have you held? You said we're supposed to give you a hard time. How many domestic trials have you held?
I've been practicing for 30 years, so well over 100.
How many times has the trial gone exactly the way you anticipated, as opposed to you making mid-trial decisions that you needed to adapt your position based upon testimony that had been entered?
I would say probably in the 80%, 80 to 90%, there's something you have to adjust to. But rarely would I think an adjustment would be that I stop presenting my case because I get flustered or I get frustrated. And I can't think of too many where I'm not allowed to put on evidence because I forgot to disclose it to the other side. I mean, things like that do happen, but the documents here was the operating agreement for the new business, which showed who owned it. It was the new wife and another partner. It was a prenuptial agreement, which confirmed the separate property nature of things. So, and again, maybe we don't carry the burden of proof on the motion for new trial, but Mr. Caruso is allowed to have a trial court review it and make that decision. To just say the grounds don't exist, I'm not looking at it, and it's just not right. And it's really the same approach with the with the civil contempt. I mean, you could say Mr. Caruso looks like a bad guy. He owes all this spousal support and he's not paying it. Well, everybody's been hit, or many of us have been hit by the financial realities of the last few years. He can't get out of the fact that he owes this money. That will be enforceable until he's paid. But it's pushing the envelope to have, I guess it's 2.5 years, 2 years and 9 months of support subject to the contempt penalty when the statute says it's a 1-year statute of limitations. So that's why I think both issues need to be sent back to the trial court and fixed, or at least addressed. And if there's any questions, if not, I'll rest.
You reserved 5 minutes.
I got 2 to go?
You held 7. 5 minutes, there you go.
Well, thank you very much.
Thank you
Appreciate
very
it.
much. We will take this matter under advisement and issue a ruling in due course. And with that, we will adjourn briefly to let the next oral argument come up. And so, thank you.
Thank you.